entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her.
Sounds like to me he's intending on getting the upper hand. Part of my problem is it doesn't seem that he can de-escalate. This fixation that he has on this infidelity, and quite frankly, if he's playing games, he's playing with the wrong judge to play those games.
Today we're in Judge Simpson's courtroom, and we're dealing with someone who seems to think the justice system is a customer service counter he can negotiate his way through. He's been violating a no-contact order like it's a gym membership cancellation. Ignore it long enough and maybe it'll dissipate. Watching him try to spin the story is rough, because he genuinely believes he's clever enough to outsmart the court. Spoiler, he's not. Judges don't play guessing games. And I didn't know has never been a winning strategy in the history of court orders. Today is about to learn that breaking a no-contact order comes with consequences, ones that move a lot faster than his excuses. So the question is, will Judge Simpson give him one more chance? Or is this the moment reality finally hits him?
Go ahead and dive in.
Your Honor.
And good afternoon again, Your Honor. Miles Drew on behalf of Mr. Busick, who's approaching my right. And can you please state your name for the record?
Ryan Michael Busick. All right, thank you. Go ahead. This is your motion.
Thank you, Your Honor. At this time, people are going to be requesting our original request of a $50,000 cash surety bond. In this case, defendant was granted a PR bond. However, the facts of this case are extremely concerning to people. In this case, the defendant went to the victim's residence and was almost interrogating her and accusing her of infidelity. He banged on the door, was told to leave by her. He then forced his way into the home, breaking the door. Officers, when they arrived, saw a broken drywall. The door was off the frame. The lock, the deadbolt was still in the lock position. After entering the house, the defendant then grabbed the victim and threw her onto a bed and was continuing to interrogate her about who she had at the residence. He then pulled down his pants and underwear to his knees, exposing himself, and she stated that he then tried to rape her. While this was happening, he was continuing to interrogate her about infidelity. She was then able to kick the defendant, run away out of the room, and exit the home, where she began to yell for help. Neighbors heard her calling for help. After that, the defendant then proceeded to chase her down and tried to stop her by grabbing her arm, causing her to fall. Law enforcement arrived shortly after, and in the videos, see that they both, it was raining, and they were both covered in rain, I guess water, I don't know. But it's very concerning, especially given that there was the broken door. And then not only after that, when he gets into custody, one of the two calls he makes, while one of them was prior to bond conditions, it was concerning to the people, given that in that call, he continues that line of interrogation, of accusing her of cheating and infidelity on the jail calls. And then the next day, when he's arraigned, after he's arraigned, he calls her again, violating his bond. And it just seems, especially given these emails that we received yesterday, he has this obsessive disposition with this victim, and it's very concerning to people given the facts of this case and his actions after this case occurs. So at this time, we're going to be re-requesting our $50,000 request. I believe that a personal recognizance bond was an abuse of discretion, Your Honor.
Response.
And Your Honor, we would admit that there was a call that occurred on the jail line, the one call that is a violation of the court's bond conditions for the no contact. I would note that all the allegations the prosecutor has gone over as it relates to the bond violations were prior to me being retained as counsel. Mr. Busick's a lifelong resident of Ypsilanti. He has a clean iChat that I've seen, meaning he has no priors and accordingly no capious history. While this is a very serious charge, and Mr. Busick does contest the allegations and is serious about facing them as evidenced by retaining counsel, I would note that there was no injuries or medical treatment and that Mr. Busick did comply with police officers. While I'm not here to litigate the facts of this case in a bond hearing, I think it's evident from looking at this case and the pending case against the complaining witness, where my client is the victim, that they have a dysfunctional long-term relationship that will no longer work out in any capacity as a romantic relationship. I've expressed that to Mr. Busick, and he's been receptive to that feedback. I think it's clear that neither party has treated each other very well. He is living currently in Ypsilanti with his mother, Lisa, who's in court today, his stepdad, Doug, who is also in court today, sister Chelsea, who is not here, but has been in constant communication in my office. His sister Erica is here in court, so he has strong family support in this matter. He does have 2 children with the complaining witness in this matter, his son Matthew, 4 years old, and daughter Scarlett, 2 years old. It's a shared custody situation where he has the kids on the weekend and about 2 or 3 nights during the week. His mom and sister are facilitating those custody exchanges. And I have expressed not only to Mr. Busick, but to the family, the importance of the no contact order, including that it means no third party contact, and have instructed the family not to discuss this case in any capacity whatsoever with the complaining witness.
This man's behavior is downright terrifying. I can't even imagine what that woman felt when he forced his way through her locked door and started grilling her like he was acting in some bargain bin spy movie. What kind of mindset convinces someone that this is a normal reaction to anything? It isn't love. It isn't passion. It's obsession mixed with delusion, and the result is dangerous. Every chance he gets, he tries to contact her like she's some appointment he refuses to cancel. You'd think a night in jail would make him stop and reflect, maybe even realize, hold on, I might be the problem here. But no, he walked into that cell and immediately started strategizing his next move. He didn't even wait 24 hours before picking up the jail phone to call her again like it was some twisted follow-up conversation. You can hear the judge's tone get colder with each detail, because this isn't a misunderstanding. It's a pattern. And once behavior becomes a pattern, the court starts seeing someone not just as a defendant, but as a genuine threat. The worst part? He is convinced as the one being wronged, which is exactly the kind of thinking that makes situations like this even more dangerous. At this point, I'm honestly curious what the defense thinks they can possibly argue, because everything they've said so far sounds desperate and hollow. This man is a danger to that woman, and everyone in the courtroom knows it.
As for work, Mr. Busick is a journeyman carpenter with the Regional Carpenters and Millwright Union. He has over 10 years experience and 6 years with the union. He has good health coverage through his job that provides for not only him, but his children with the complaining witness. It's our understanding that the complaining witness does not work. And even though there's no child support order in place, he does also provide support to the mother of his children for expenses when she has the kids in her possession. In other words, he is the provider for these children, and they get their health insurance through his job. And that appears to be the only avenue for their health insurance. And he is at risk of losing this job should he go to jail. So, Your Honor, I would, conclude by saying that counsel was retained after all these allegations, that Mr. Busick has no prior criminal record. And I think him and the family maybe didn't understand the scope and importance and severity of a no contact order. I have counseled them at length about that no contact means for any reason.
What would you have understood about that, counsel?
Your Honor, I think it's somewhat common for people. I know no contact means no contact, and it's very straightforward, but I think people that have no prior history with the criminal justice system sometimes do not think things are as straightforward as they are. He certainly makes no excuses for his behavior, and he knows it's inexcusable to make those calls. We would be asking for a $25,000, 10% with the tether.
But he's still, from the allegations, and I'm not making necessarily a presumption of his guilt of those, but he's making certain allegations regarding her infidelity, then ultimately gets arrested. After creating, some damage, or allegedly creating some damage to the premises, and things not going well because now you're in custody, you're told by the magistrate not to have contact, and what does he do? He has contact about the same thing that the allegations are about.
Right. I understand the court's concerns. That's why we are asking for a cash bond in this matter. I would point out that, since he was assaulted in March by the complaining witness, which resulted in felonious charges, these have been some of the hardest and trying months of his life. He has not been in his right state of mind. We're going to be looking to getting him, treatment while on bond and getting evaluated for a treatment course so he can get some support in facing this tough time, Judge. Ultimately, there's no excuse for making the phone call on bond. We understand that the allegations are concerning. We can test them as it relates to the case.
Tell me how I can even be sure that he's going to follow this court's conditions.
Well, I think you have his family sitting right here in the courtroom, that they're accountable, good members of our society that are going to be looking out and holding him accountable. They have, financial interests involved in this case as well. They are living with Ryan. He has no prior record, which I think speaks to the fact that they raised him pretty well up to this trying point here. And I think that the tether, was put in place after these phone calls, and there's been no issues with the exclusion zone. So I think in that respect, the tether is working, Judge. And I think you have members of the community that will be looking out to assure that your court order is followed by Mr. Busick. And I think this is a real wake-up call for him, quite frankly. This isn't a situation he's used to being into, given his clean criminal record. And I think he's standing up a little bit straighter now after this and understands just how much is on the line after having a stern talking with counsel both last night and prior to court today about the severity of the situation that he's in here, Judge.
In the 14B case, isn't there a no contact?
There is a no contact order in place.
So what's he doing there? That's the part that's troublesome to me. He has a case in which he's the alleged victim, right, counsel?
Correct.
He knows there's a no contact provision, right?
Yes. Well, the no contact provision would run to the defendant in that case, which is the complaining witness in this case.
How it works. That's not my point. My point is, why is him knowing that? Why is he at her residence?
Well, Your Honor, I would say that I think, these no contact orders, I mean, he shouldn't have been seeing her, but this is a 10-year relationship that goes back to when they were 16 years old. They have children in common. While I certainly would have liked if this was handled.
So that's all fine and dandy. But he knows she's not supposed to have contact, right?
Well, he believed the condition was dropped. But I mean, I would agree that he should not be having contact
where
with her.
He get the idea that it was dropped.
I'm not sure, Your Honor.
Your
What is so
Honor,
confusing?
what exactly is confusing about a no contact order? It could not be more direct. Do not contact a person. That's it. No hidden clauses, no complicated language, nothing to interpret. Yet here he is, still trying to convince the judge he didn't understand it. Or worse, that he thought it was optional, like some sort of store coupon he could choose to use or ignore at this point. It's hard to tell whether he truly didn't get it or if he's trying to play clueless because the truth won't do him any favors. And then the defense tries to shift the blame onto the victim, as if bringing up old drama somehow excuses kicking down a door, showing up uninvited, and violating court orders. It's embarrassing. Sure, he doesn't have a long criminal history, but that doesn't wipe away the seriousness of what just happened. When someone commits a violent act and immediately violates a judge's order afterward, the clean record argument starts losing its shine. Judges care about patterns, about safety, and about whether someone respects the authority of the court. And on all three fronts, he's falling short, and then the story changes again. First, he claims he didn't understand the order. Then suddenly he insists he thought it had been dropped. Which one is it? You can't accidentally violate a court order and also claim you believed it magically vanished. If you're going to stick to a story, at least pick one.